This is a 4-part series on the Ohio Realtors residential real estate purchase contract. I will be going through sections of this purchase agreement and giving further explanation for you to use in training. We are using the annotated version, which is the copy you'll see on the screen that is also highlighted in yellow, which is definitely a wonderful tool to use as you're learning to navigate through this document. On the very first page, we start with lines 1 through 14, and those are definitions. They're specifically put there for your buyers and your sellers to understand the language that is used within this purchase agreement and make it more comprehensive for them. So line number 1, general definitions and terms. The following terms used in this purchase contract are defined as follow. Buyer includes all persons, entities identified in the contract as purchasing the property. Number 3, seller includes all persons, entities identified in the contract as selling the property. Line 4, parties includes both buyer and seller identified in the contract. Number 5, contract includes this agreement and any addenda and amendments agreed upon in writing by all parties. Property, line number 6, is the real property described below, including all rights, title, interests, appurtenances, buildings, improvements, and fixtures owned by the seller, except as provided otherwise in this contract. Number 8, broker, includes without limitation the brokerages and any affiliated brokers and agents involved in this transaction, and shall include both the seller's broker and the buyer's broker unless provided otherwise. Number 10, days, means calendar days, including holidays. Any reference to the date and time shall be the U.S. Eastern Time Zone in Ohio. 11, date of acceptance of this contract or any counteroffers, amendments, or modifications thereto shall be when the final writing is executed by all necessary parties and is delivered to the offering party or their broker. Number 13, days after acceptance start at 12:01 a.m. the first day following the date of acceptance. Number 14, EMD means an earnest money deposit paid by the buyer. Note, these definitions are set forth the meanings of repeated and important terms throughout this contract. Important items to take into consideration include the defined term for days, meaning calendar days. Please note that although the singular tense is used in several instances, buyer, seller, broker, etc., these terms include all buyers, sellers, and licensees involved in the transaction unless provided otherwise. That concludes the definition section. Line number 15, offer. The undersigned buyer offers to purchase from the seller the property described below on the terms contained in this offer. On the date of acceptance, this offer shall become a legally binding contract. Line 17, the property. This is where you'll write in the street address, city, village, or township, county, state, and zip code. Line 18 is where you will fill in the parcel ID number or numbers. And 19 gives you the opportunity for further described as. That is not a mandatory line. However, there are many areas in the state of Ohio that like to identify the property, such as a single-family home with attached garage, a condominium unit with a carport. Those are just 2 examples, and that line is optional to be used. Now we'll read the notated section. The brokers should be extremely careful to insert all relevant and correct identifying information for the property, including all county parcel numbers, which could be more than one. This is especially true for rural properties and condominiums, which could have several parcel numbers. This information can be found in the MLS and confirmed on the county auditor's websites. Again, like it mentions in the notated section, it mentions the word brokers, which also the word agents is a part of that, just not identified there. Line number 20, purchase price. The purchase price shall be the price that the buyer is offering in U.S. dollars. Line 21, the form of payment. The buyer shall select an initial one of the following. Line 22, which is 2A, initial here, cash. The buyer will pay the purchase price in cash at closing and agrees this contract is not contingent on financing. Line 23. Now, this is an area where default dates start to show. This purchase agreement has default dates throughout it. This is the first example. Within blank days, 3 days if left blank, after the date of acceptance of this contract, the buyer shall deliver to the seller or the seller's broker evidence reasonably satisfactory to the seller that there are readily available liquid funds necessary to complete this transaction. If the buyer does not deliver such evidence within the time period indicated above, or the evidence provided is not satisfactory to the seller may terminate this contract by delivering written notice to the buyer or the buyer's broker. In bold font here you'll see the seller's failure to deliver the written notice of termination within 3 days of receipt of the evidence or 10 days after the date of acceptance of this contract, whichever occurs first, shall constitute a waiver of the seller's right to terminate pursuant to this provision. Let's go up to the notated section. If the buyer is paying the purchase price in cash at closing, then the buyer must provide evidence of such readily available liquid funds to the seller, or the seller may terminate this contract. Such evidence could include a bank or brokerage statement with account numbers redacted. Timing is very important if a party wishes to terminate under this provision. Now, under line 23, the buyer can put any amount of days in there that they feel comfortable. The seller can counter those days if they think they're too long. And if no days are written, again, it will be 3 days would be the default date because it wasn't added there. Again, if you do have proof of cash when you're writing the offer, just go ahead and put 0 days and present it with the cash proof at that time. Okay, moving on. Line 29, which is number 2B, initial here, financing. This contract is contingent upon the buyer obtaining financing for the purchase of the property, subject to the below provisions. Line 31, loan application within blank days, 7 days if left blank. After the date of acceptance of this contract, the buyer shall make formal application for a conventional FHA, VA, USDA, or other, of which you should specify in that line what the other is, loan, and pay any fees required at the time of application, including the appraisal. Line 34, buyer shall provide the seller or the seller's broker in writing with the name of the selected lender and, if requested, the intent to proceed notice. Buyer shall act in good faith and with reasonable diligence to acquire loan approval by, line 36, providing all necessary information and documentation to the lender during the mortgage loan application and approval process in a timely manner, and, line 38, maintaining the buyer's credit in good standing and funds to close. Line 39, additional financing terms and conditions, i.e. down payment, amount, loan terms, loan-to-value ratio, etc. The lines for line 39 and 40 are not required, or they're simply optional for those agents who prefer to fill that information in. The notated section. It is important for a buyer's broker to ensure the correct selections are made with an emphasis to their clients on deadlines. Some areas of the state typically have buyers disclose additional loan terms, such as the down payment amount or other loan terms, in an effort to make their offer more desirable. This information could be inserted in the additional financing terms and conditions under 2B. With the respect to intent to proceed notice mentioned above, some lenders will issue a formal intent to proceed notice document. However, some lenders will simply send email correspondence confirming as much. This is driven by the specific lender and local custom in the area. The critical takeaway is communication between the brokers. Line 41, loan commitment. The loan commitment shall state the lender will provide financing for the purchase of the property, subject to conditions and qualifications imposed at the lender's discretion. Loan commitment. Buyer shall obtain a loan commitment within blank days, 45 days if left blank, of the date of acceptance of this contract, considered the loan commitment period. Line 44. The buyer shall deliver one of the following to the seller or the seller's broker by the end of the loan commitment period. Line 45. Number 1. Written notice from the lender of loan commitment with or without conditions. Or line 46. Number 2. Written notice from the lender of the loan denial and notice of termination of this contract. If provided by the end of the loan commitment period, the earnest money deposit shall be dispersed pursuant to paragraph 6 earnest money. Buyer's failure to deliver this notice of loan denial and termination shall constitute a waiver of the buyer's right to terminate this contract for loan denial. Line 49. If the buyer fails to deliver either notice to the seller or the seller's broker by the end of the loan commitment period, the seller may terminate this contract by delivering notice of termination to the buyer or the buyer's broker within 3 days after the expiration of the loan commitment period. Any EMD received shall be dispersed pursuant to paragraph 6 earnest money. Line 52. Number 2C, initial here if other financing, and specify the attached addendum if necessary. Note, paragraph 2C could be used in unique financing situations, including seller financing or land contracts. Line 54, 2D, change in funding. Any change in the source or amount of the buyer's funding must be agreed upon in writing and signed by both parties unless the change does not impose additional obligations on the seller and does not impact the buyer's compliance with the dates set forth in this contract. If seller consent is required, such consent shall not be unreasonably withheld. Line 57. This is something new to our area in Northeast Ohio. Number 3, appraisal contingency. This contract is or is not contingent upon the property being appraised by a licensed appraiser at no less than the purchase price. If the property appraises at less than the purchase price, the buyer may terminate this contract by delivering written notice and a copy of the appraisal to the seller or the seller's broker no later than 5 days from buyer's receipt of the appraisal. The buyers may, at the party's option, use the applicable time period to reach a written agreement as a result of the appraisal. Failure by the buyer to terminate this contract within the applicable time period constitutes a waiver of this contingency. If neither option is checked, this section does not apply. Note, paragraph 3 could be used in situations involving a unique lender requirement or where a cash buyer wants to make their performance contingent on the property appraising at or above the contract price. If the appraisal is short, the buyer may terminate with written notice or attempt to reach an agreement. Deadlines are also critical here. So again, that is an area that's a little bit newer to us, but the language was very well spelled out so that people understand it. And if you're in a situation where a buyer does check the box that says it is contingent upon the property being appraised, the seller in negotiations absolutely has the right to counter back by checking is not. That is an area of negotiation. It isn't a hard hold on the buyer's end. Line 62, number 4, real property closing and sale contingency. The buyer's ability to finance this purchase and or perform the terms of this contract is contingent on, if applicable, check 1. Line 64. The closing of real property owned by the buyer and located at, this is where you would put the home address of the buyer, which is currently under contract. The buyer shall provide written notice to the seller if the pending contract is terminated. Line 66. The sale and closing of real property owned by the buyer, which is not currently under contract. The parties agree to the terms in the attached real property sale contingency addendum. Line 68, if neither option is checked, this section does not apply. Note, Ohio Realtors provides an addendum for use in transactions requiring the prior sale of a buyer's property. While not required to be used, it is highly recommended. Additional terms or conditions should be prepared by an attorney. So we do have uploaded the property addendum that they are talking about. This section, line 62 through 68, addresses what we used to have in our form set as a house sale contingency or a house sale concurrency addendum. It is now addressed, the language is addressed right here in the purchase agreement, and we have traded out those two addendums that we used to use with the Ohio Realtors addendum, and that is also available for your use. Line 69, settlement charges. The seller agrees to pay actual settlement charges incurred by the buyer, including, but not limited to, discount points, closing costs, documented prepaids, lender's policy of title insurance, and any other fees allowed by the buyer's lender in the amount not to exceed a dollar amount or on 71 a percentage of the purchase price. If no amount is entered, the amount shall be zero. This paragraph does not apply to the cost of an owner's policy of title insurance pursuant to paragraph 17, title search and insurance. Again, lines 69 through 72 addresses the language you used to write into our purchase agreements addressing concessions the buyer is requesting, such as closing costs and prepaids. Line 73, earnest money. This section is different than what we are used to again in Northeast Ohio, so please pay particular attention to lines 73 through 83, and I will address all of that when I read through it here. Line 73, earnest money. No later than blank days, 3 days if left blank, after the date of acceptance, buyer shall deliver an EMD in the amount of whatever amount the buyer is offering in earnest money goes there, which shall be held by the following third party, and the line there states the holder. For our brokerage, this is where you would write in the title company's name because they will be holding the earnest money. Different than our previous purchase agreements, this purchase agreement has two different areas where the title company's name will be identified. So please be certain that the same name of the title company is addressed in both of those sections, and if a counter offer should occur, please be sure to change it in both sections. Moving on. If a third party other than Ohio broker is designated to hold the EMD, the parties agree to execute any escrow agreement required by the holder, the terms of which may supplement but not conflict with this paragraph 6 of earnest money. That's an area where a title company may request that they sign a document allowing them to hold it. That's not anything you need to prepare. It's just information there so that the buyer is made aware. Line 77. Within 5 days after the EMD deadline indicated above, the buyer or the buyer's broker shall provide written confirmation to the seller or the seller's broker that the buyer has made the EMD by the date required. If such confirmation is not received by this date, the seller may terminate this contract by delivering written notice of termination to the buyer or the buyer's broker within 3 days after the confirmation of the EMD was required, or at any time prior to receiving confirmation that the EMD has been made. Line 81, the EMD shall be deposited in the holder's trust account. Unless agreed otherwise by parties in writing, the EMD shall be disbursed at closing by the holder in one of the following ways: returned to the buyer, applied to the purchase price, or if held by a broker, retained by the broker, and credited toward the broker's commission. Line 84, if this transaction fails to close, the EMD shall be disbursed in accordance with the written instructions signed by all parties to the contract. In the event of a dispute between seller and buyer regarding the disbursement of the EMD, The holder shall maintain such funds in its trust account until the holder receives written instructions signed by the parties specifying how the EMD is to be dispersed, or B, a final court order that specifies to whom the EMD is to be awarded. If within 2 years from the date the EMD was deposited in the holder's trust account, the parties have not provided the holder with such signed instructions or written notice that such legal action to resolve the dispute has been filed, the holder shall return the EMD to the buyer with no further notice to the seller. Now in the notated area. In many areas of Ohio, it is common for earnest money to be held by a title company or other third party rather than a broker in a transaction. This section is drafted to account for this possibility by referring to the term holder. If the holder is not a broker, this section requires the parties to sign an escrow agreement. However, the terms for disbursement of the earnest money mirror the requirements for brokers under Ohio license law unless the parties and the holder agree otherwise. Note, the buyer's broker must provide written confirmation that the EMD has been deposited to the seller's broker. This notice must be furnished within 5 calendar days, and failure to do so can result in the seller terminating this contract. I'd like to revisit some areas of this section before we stop here. So, what this means is that this additional language was added that we have not had in the past, primarily because it has been a common problem in recent years for buyers to not get their earnest money in on time despite what the purchase agreement may have stated, in which case the seller was held up in all of their plans and their commitments while they were being certain that the buyer was moving forward. This tightens this area up, and any of the deadlines and trigger dates as we consider them in this purchase agreement are merely put in there to help the buyer and seller continue to move through this purchase agreement as they have agreed to in writing. So, under line 73, where earnest money starts, the way that this means is under line 77, within 5 days after the earnest money deadline that was indicated above. You as a listing agent must have received proof that the earnest money was deposited, and that can come in any number of ways. If you represent the buyer in this transaction in our brokerage, I would like for you to receive the check in with the title company, see when the earnest money was deposited, receive written proof of that, forward that to the listing agent, forward that to your client, and be sure to upload that into your loop. If you represent the seller and this occurs, you also are required under Ohio licensure law to be certain that that earnest money was collected. That has always been true under Ohio Realtors license law. So you want to be certain that that money was collected. So if for some reason the other agent is not getting you proof of that, it is your responsibility to get that proof yourself as the listing agent and to share that with your client and to add that to your loop. So in the case of the possibility of the seller being able to cancel under this, please note that hypothetically, if line 73, if it was in there 5 days after the date of acceptance, the buyer shall deliver the earnest money deposit. And if you as the listing agent check on the 6th day and it has not yet been deposited, under line 77, within 5 days after the earnest money deadline indicated above, the buyer or the buyer's broker shall provide confirmation, okay? And under line 79, the buyer, by delivering written notice of the seller can terminate here within 3 days. So, in this example, if 5 days was put in there, on days 6, 7, or 8, if the earnest money had not been deposited by the end of the 5th day, and on days 6, 7, and 8, the seller has the right to terminate this purchase agreement. But they have 3 days to make that decision. They can decide by the end of the 8th day. Even if they have not yet sent notification that they're terminating the contract, and the buyer were to deposit that money on days 6 or 7, the seller still has the ability contractually to cancel this agreement because it was not deposited by the originally intended and agreed upon 5 days that was written for this example I'm talking about on line 73. So it's critically important, as you'll see some of these trigger dates in and throughout this purchase agreement, for both real estate agents, the one who represents the seller and the one who represents the buyer, to stay actively involved in the deadlines in these purchase agreements, because no matter which party you represent, that client will have the opportunity to consider canceling in certain areas. So it is your responsibility as the licensed agent to make certain that your party is aware of areas that they might be able to cancel if the contract isn't moving forward. And as I mentioned, these deadlines were put in here not to get people canceling their purchase agreements, but to keep the transactions moving forward. It is very often that a seller is trying to purchase another property and moving forward with their section of that. And sometimes we got to stopping points because the buyers and sellers were not participating on their ends to get these things accomplished. This is the stopping point I'm going to start in for the first section of this document. So those are lines, this is part 1, and those are lines 1 through 89. I just want to make a note here to make you aware that this information that I'm contributing here is for training purposes for our brokerage at Keller Williams Greater Cleveland Northeast. If this were to be shared with any other brokerages for training purposes, please note that I am giving advice to our agents at our brokerage for how that should be handled within our company. And if you have any questions of more magnitude regarding what was displayed here, please be certain to check with your own brokers and managers to be certain they agree with the language I've provided you with. Thank you.